Module 3, Part 3, How Claims Are Laid Against You. We all have different life experiences, social conditioning and beliefs. We all have an obligation to uphold the peace. Claims must be expressed to be resolved. Has a breach of the peace occurred, or is one about to occur? 3 things must be shown by the claimant. Rebuttal of claim and failure to respond. Rebuttal of a reminder, witness 1, and failure to respond. Rebuttal of letter before action, witness 2, and failure to respond. What else is humanly possible, and default summary judgment.
Yeah, so what we're basically going to look at now is dispute settlement and the importance of responding to other people's claims. So, as we know, we all have different life experiences. We're all equal under the law, but we all are unique. So, depending on our social conditions, that creates our beliefs. That means that anybody can have a different perspective on the same thing. And therefore, as a society, to uphold the peace, we need to resolve any dispute, any claims that anybody may have against anybody else. And that's under our obligation to uphold the peace, as we've seen before, and this is what it's all about, is upholding the peace. And part of that upholding the peace is if somebody lays a claim against us, if we don't do everything possible to resolve that dispute, we are now actually in breach of the peace, we're breaching the peace. Firstly, the way we go about it is we must express the issue, and we need to try and make sure that we understand what the issue really is. So the claimant, they must prove their claim, and therefore they must express the claim in a meaningful way so that we can try and attempt to get resolution. We've said that for breach of peace, we need to, at the time, provide the evidence, and for this we need to show that it actually related to harm which was actually done or likely to be done to a person or in their presence to their property. So the claimant must show 3 things: the fact of the events detailing your involvement, if the person that they're laying the claim against. Secondly, they must be able to show they have the right to demand your performance. And thirdly, they must show that you are under an obligation to perform at their command. And hence why we're always looking at it, I'm innocent until proven guilty. If you're the claimant, if you're somebody approaching me, you introduce yourself, you starting the claim. And every step of the way, every time, they need to show a cause of action. So most people believe legislation is law and are familiar with somebody coming up and saying, you have breached section blah blah of the act blah blah. So those are the claimed facts of the matter and that you are in breach of it. Now, to remain in honour, and equity is all about honour, good faith and clean hands. If somebody lays a claim, they need to give you reasonable time to respond. So when we looked at about being in detention in the interview, it's not reasonable that you're in a stressful position and you need to respond at the time, especially when you're against a skillful opponent who's trying to draw out things which may result in other things. So to remain in honour, you must respond, and if you fail to rebut the claim, it's to the claimant, it's saying, well, you're not disputing this matter. But what's happened is that he's put you with the facts, or his version of the facts, and you failed to correct it at the time, which is why with the interview we said, send your questions, you've got my name and address, and I shall respond. That way you stay in honour. If you don't respond, they'll send you a reminder, and the reminder reinforces the facts of the original claim, and it records that you acted in dishonour, and hence are breaching my peace because I still believe it, that I have a lawful claim. Again, if you do not respond to that after a reasonable amount of time, a second reminder, which is called a letter before action, is sent, and that there becomes witness to of the dishonour of not settling the dispute, and it's witness to then also of the record of the facts. Finally then, what choice is left as a claimant if somebody is not responding? Once you follow this pre-court procedure, as they call it, pre-action protocol, you need to settle your dispute, and then you need to take it to public dispute resolution. You've done all that's humanly possible to try and resolve it in the private, and you take it to the courts, and this is when the courts will, if you don't respond, you will get what's known as either a summary judgment or a default judgment, and this is necessary for us in society to make some a settlement, a method of settlement for dispute, so that people can overcome the whole dispute thing to keep the peace.
Mm-hmm.
So we must have a dispute resolution method to create finality. But because it's a summary judgment, it's automatically up to the right of appeal, because you may not have this knowledge at the time. And once you have the knowledge, then you can correct, because it's about equity, we keep saying. Equity is about good faith and clean hands and honour. If I didn't have the knowledge, I didn't know what to do. So at the time, I could do no better, but now I have the knowledge, and therefore now I can resolve the dispute. And hence there actually in equity is no statute of limitations. A statute of limitations is a legal thing, because equity will not suffer a wrong without a remedy, and this can be, once you gain the knowledge to get the remedy, then you can get the remedy. So all about dispute resolution, and the reason we need it is to uphold the peace.
Very good.
Right?